morning. We are here this morning in the Greene Superior Court. This is the second day of July 2024. We've got one case that's set for pretrial conference entitled the State of Indiana versus Craig Hendry, and then another case that's set for a hearing. And then in the CM97 case, there was the motion for summary judgment that was filed on the 5th day of June. The court considered that as a motion to dismiss instead of a motion for summary judgment. So the court is considering that the defendant then has filed the motion to dismiss, and the state filed a response to that motion on the 18th day of June. So primarily, that's what we're here for today, and the other case, the 100, we will also be resetting a pretrial conference in it. Mr. Hendry, like I indicated, the court's showing that I'm interpreting your motion as a motion to dismiss, and just to make sure I understand, you're addressing count 1 in your cause. Is that correct?
That is correct, Your Honor.
Okay. And sir, since you're representing yourself, you can go ahead and make any argument that you want to the court.
Understood, Your Honor. You mind if I get up and stand at the... Okay. I appreciate that.
Did you receive a copy of the state's response?
I did, Your Honor. Yes. I'll start off by saying good morning to all the parties. All right. All right, Your Honor, while a flashlight is meant to be used to bring light to those things that would otherwise happen in the dark, it can also be used as a weapon to beat somebody with. It can be used to commit a use of force. Likewise, the office of the prosecutor is meant to bring justice to those who have been wronged, but it too can be converted into a weapon to beat its opponents into submission with. Judge, when the state and the defense showed up for the initial hearing on April 29th, 2024, the defense asked a question pertinent to this very case and this very charge. I asked if a use of force was required for this very allegation to have been brought against me. The prosecution seems to have thought it was relevant too, as after Your Honor replied to my question, Brent Seymour, counsel for the state, interjected immediately after, claiming that a use of force is not a requisite for certain verbs in this Indiana code. But if Mr. Seymour's position was that a use of force had occurred in this case, why did Mr. Seymour feel the need to clarify that the IC code did not require a use of force? I think any reasonable person would conclude that Mr. Seymour felt it so necessary to interject that a use of force was not a requisite for certain verbs because he knew that a use of force did not occur at that point in time. He knew that, and he still believes it. In response to paragraph 3 in the state's response, if the prosecution did not know the law on this matter, he should not have advised the court so definitively as if the prosecution did know the law on this matter. Furthermore, the prosecution should have made themselves aware of the case law surrounding the forcible element of this crime and the necessity thereof previous to charging me with a violation of criminal law. I think that if I had advised this court of anything to do with a matter of law, and I did so in let's just say it, if I did so in error, I think that I would be certainly reprimanded in some way for doing that, or at the very least, I would be looked at with less credulence in the future if I were to bring some faulty point to the court's attention, representing it as fact. So in paragraph number 5, the prosecutor's response, the prosecution attempts to justify their pivot from their previous argument of there is no requisite for a use of force for this statute to saying now that the shining of a flashlight is a use of force. All right. Or perhaps the pressing of a button to activate that flashlight is the use of force that the prosecution is relying on in this case. That is what he says in paragraph 5. Of course, I would remind the court that he has now pivoted from his previous a position of no use of force is required for this statute, well, that now there is a use of force required, and not only that it is required, that he so adamantly denied that it was required, but now that it applies to this case as well. Of course, if it didn't apply to this case, if the prosecutor didn't think it applied to this case, why even bring it up? Why even make the point? It's because he knew at the time there was no use of force. A flashlight is a use of force. But then, I'll go on, saying the state cites Bringle versus State, and I believe that is in paragraph 5, Your Honor. The case is wholly irrelevant as far as the defense can understand, as the obstruction in Bringle arose out of a failure to identify by Bringle whilst he was the subject of a traffic stop. The situation then escalated after a refusal to identify to the point that the police had to forcibly enter Bringle's vehicle to do their job. So, of course, locking the door to prevent the police from physically entering the vehicle could be seen as a way of obstructing or interfering the duties of an officer. Contrast that situation with the case at hand today. The defense was recording a traffic stop from a reasonable distance. By the account of Mr. Van Horn's affidavit, he was sitting waiting on a tow truck, and his investigation, by any reasonable person's judgment, had concluded. As the subject of the traffic stop had exited the scene on foot, I had seen this myself. Okay. Mr. Seymour's attempt to apply Bringle to this case that we have before us, a case titled State of Indiana versus Craig Hendry, it's nothing more than an attempt to cause further damages to the defense, is in my position, deny just and proper relief to the defense, and to equate the shining of a flashlight, which had far less effect on Mr. Van Horn visually than any headlight turning a nearby corner, and for a significantly shorter period of time than any nearby vehicle would have shined its headlights on Mr. Van Horn as a necessity of driving by. But the prosecution is trying to equate this to preventing an officer in a physical manner from executing his lawful duties. It is the defense's position that his lawful duties were already accomplished. The traffic stop was over. Right? The subject of the scene had left. All right? The officer was waiting on a tow truck to come pick up the vehicle. He didn't have anything more to do. He's just sitting there waiting. That's it. Sitting in his car waiting. All right. So ultimately, egos were hurt on this night, but no law was broken by the defense. All right. So then we're going to look at number 6, number 7, paragraph 6 and 7 in Mr. Seymour's response. Through the state's this is a quote. Through the state's research, only one case was discovered that was on point regarding obstruction of an officer's vision without physical contact being made. In Clemens versus City of Hobart, 2019. Now, I have got the case before me here, and I'm not going to read it all to the court because the court does have access to it. It is cited in Mr. Seymour's response to my motion. Ultimately, the City of Hobart court, they looked over a few different pieces of case law. They looked over Spangler. Looks like they looked over Johnson versus State, Guthrie versus State. And ultimately, they came to a conclusion. But I think making the claim that it's on point in this matter is a little bit of a stretch. First off, this case, City of Hobart versus Clemens versus City of Hobart, sorry. This arises out of a police officer being on private property. I think that the court actually had a little bit of a difficult time deciding whether the guy was even in his public capacity. He was working, I believe, a private place, a Chuck E. Cheese, and the courts were really having a hard time deciphering between whether the guy was working in a private capacity or whether the guy was working in a public capacity. But not only that, the differences don't stop there. I believe that there was a bit of a violent element to this case. It's just not, it's a civil case. There's a whole bunch of differences between it. Trying to equate the two it's an extremely far stretch from what the defense can say. But this is a quote from the case log, City of Hobart. Quote, even viewing the evidence in light most favorably to the plaintiff, that is, viewing the video evidence as suggested, plaintiff inserted his arms between Officer Viator and JR and blocked Officer Viator's view, but did not touch him. This case does not seem akin to Spangler. In Spangler, the subject was walking away, which the Indiana Supreme Court viewed as passive resistance. Here, plaintiff injected himself into an ongoing arrest with his limbs, which is not passive at all. To this court, plaintiff's behavior is more like the subjects in Guthrie and Johnson because he interfered in a meaningful way that extended beyond mere passive resistance. Accordingly, the court finds that plaintiff's conduct satisfied the Indiana resistance rule, supplying the underlying offense necessary to support finding that Officer Viator possessed probable cause to effectuate plaintiff's arrest and detention. And of course, the reason the court is even mentioning, probable cause and all this stuff is because this case is a civil matter, and the defendants in the case were filing for a motion for summary judgment. It's a totally different type of case, totally different body to it and everything. But on top of that, in every single case referenced by the prosecution, with regards to City of Hobart, all the case law connected to it, every single case, the person subjected to the statute used their limbs and body in a meaningful way that resulted in an obstruction or interference with the officers carrying out of their duties. In the case at hand, the one captioned State of Indiana versus Craig Hendry, there is no allegation of defense interjecting limbs or body parts between the officer and a subject or a person or item that is a subject of an officer's investigation. We don't even have the officer at hand, Mr. Van Horn, in the midst of an investigation. He is waiting on a tow truck, and as far as being on a roadway like the officer was, he can expect to be hit with various different headlights all the time, ranging from 700 lumens to 3,000 lumens as is allowed by federal regulations in the United States. Further indicating that far from an abnormal interference or obstruction to his duty, the flashlight that defense shone at the officer was actually fairly normal and insignificant. The prosecution goes so far to admit that one of the major differences between the current case and the City of Hobart is that in the City of Hobart, the offender used his, quote, physical body, unquote, furthering the defense's point that no forcible element exists while using a tool that emits photons. Photons, Your Honor, it is well known in the scientific community that photons do not contain any mass. In order to commit a forcible element, kinetic energy is required. It's impossible to get kinetic energy if you don't have mass. And so in order to use force, you actually have to have something that is capable of inflicting some kinetic energy on another object. But of course, light doesn't do that. If you get hit with light, it doesn't inflict any kinetic energy. So in paragraph 8, now we'll move on to paragraph 8 of the state's response. The state makes a ridiculous claim when he says that locking a door in order to prevent an officer from entering a vehicle, which he has a lawful duty to enter, is akin to shining a flashlight or pressing a button. And now I want to make it clear that in the case of the state references where they try to equate a pushing of a button in a car door to a pushing of a button in a flashlight. The car door is a barrier, Your Honor. The car door is a physical barrier between a police officer and a subject of an investigation. But if a police officer has a lawful duty to actually enter a vehicle and effect an arrest on a subject of an investigation, then locking that door, securing that barrier, if you will, is clearly in violation. It's clearly obstructing resistance. But pressing a button doesn't create a barrier. It doesn't create an obstruction. Maybe it creates an inconvenience, but it doesn't have anything. It doesn't have any relation to this pressing of a button to lock a car door. By the way, there were other factors, and the state admits that as well. There were other factors in that case as well that makes it reasonable to conclude that the guy was obstructing or interfering in that case. So then I'll move on in paragraph 9 of the state's response. The state makes yet another highly irrelevant point by claiming that being exposed to a bit of light might pose a risk to an officer. While hypothetically anything could have happened, the defense would ask the court only to consider the reality of the situation and the facts at hand. The reality is that no threat was posed to Officer Van Horn by the defense. I actually have some statistics, Your Honor, and should it please the court, I would like to comment on them verbally, but then at a later date, I'd like to reserve the right to enter into the record the statistics in their physical form on a piece of paper. So that
I'm going to have to object to that. There's been no basis laid that these statistics are accurate.
Do you wish to respond to his objection?
The statistics, the validity of them has not been mentioned yet because the source hasn't even been mentioned yet. The source is actually the government. It is the PBS.org NewsHour publisher, and that publisher is actually a government publisher, which I think lends a little bit more credence to them in a government court. So while the state might object, I would ask that the court reserve the right to rule on that objection until it has actually seen the source of the materials that I'm willing to provide to the court. The validity cannot be attested to or it can't be shown to be incredulous if the prosecution doesn't even know what the contents of the material are. How could he possibly? So, thank you, Your Honor. So, what I have done, Your Honor, as far as statistics goes, is I have found on a law enforcement officer. Yeah, I can't get the full .org, but of course I'll provide it to the court. This is a law enforcement website. I believe this is a 901c3 or a nonprofit organization that has been created to bring awareness to police officers and the dangers that they are exposed to every day in their job. And what they've done is they've compiled statistics on officer deaths. Between the years of 2014 and 2023, there were a total of 2,519 officer deaths. And Your Honor, what I've done is, from this same website, I have taken statistics compiled from 1980 to 2018. I have taken all of the police deaths. I've compiled a statistic average for how many police deaths are caused by shootings, which is the only statistic here that would imply that somebody other than somebody else, another person, caused the death. And I have taken that percentage and I have applied it to the deaths from 1980 to 2018. I've gotten a statistic that about 21% of police officers that have died during those times have died from being shot. Now, the defense does not know how many members of the public shot them. The defense only knows that 1,500 police officers as a whole number were killed on average from about 1980 to 2018. So these statistics, the defense has compiled through basically just using math to get the correct statistics from other statistics that other websites and other organizations have compiled. So the defense's point in sharing this is to make clear that if anybody was in danger during the times in question, it was the defense. As PBS, the publication that I mentioned before, estimated that from 1980 to 2018, the same amount of time that the 1,500 police officers were killed from being shot, about 30,000 citizens, members of the public, were killed extrajudicially by the state. It could be seen as executions or killings or unfortunate events. But in any matter, 30,000 U.S. citizens were killed with police violence, and 1,500 police officers were killed during that same time frame from being shot. According to the statistics I've compiled, a U.S. citizen is 20 times more likely to be shot or killed through the use of police violence than a police officer is likely to be shot, only shot, and killed by the public. Now, so the 20 times comes from taking 30,000, dividing it by 1,500, you get the number of 20. But that's just some statistics I would like the court to consider, especially after I enter the websites, the source material into the record. I actually apologize for not having that ready as of right now. That is an oversight on my part. And I got just a few more things. I want to thank everybody for being so patient with me. So this is an excerpt. It says, "It is well settled that to constitute, quote, force, unquote, an action must be, quote, made in the direction of the official," unquote. That's Spangler versus State. And this requirement applies whether force is based on physical contact or a threat of strength, power, or violence. And that "or" is very important. This requirement applies whether force is based on physical contact or a threat of violence, power, or force. Strength, power, or violence, sorry. That would imply that, the case law that backs this up is Walker versus State, Pogue versus State. And I actually have the case law here for your honor to consider. I believe I have in the two relevant cases the language highlighted for the court to consider. Of course, the prosecution is entitled to a copy of that as well. But what this implies is that there are two ways that something could be considered force. And it's laid out here in this case law. And this is, by the way, this is an excerpt, I believe, from a great Indiana Supreme Court dissent. So this is, I believe it's from a dissent, but it's also shown in actual case law at the appellate level. And I have that prepared here as well. The Supreme Court dissent is only quoting these, by the way. The Supreme Court is not making any sort of assertion that is not already laid out clearly in case law, in an appellate court case law. So it's or. That means there's two things, one or the other. The first thing, there has to be force, and action must be made in the direction of the official. Okay? Or it has to constitute a threat of strength, power, or violence. Nothing that has happened in this case meets either of those requirements at all. All right. Let's see here. Yes, I would like to read out one last thing I've made here, and then I'd like to deliver these to the court. So, what I just read, and I'm going to read it again. It is well settled that to constitute force, an action must be made in the direction of the official. Spangler versus State. This requirement applies whether force is based on physical contact or a threat of strength, power, or violence. That is Walker versus State and Pogue versus State. This requirement applies whether force is based on physical contact or a threat of strength, power, or violence. This requirement is a requirement, Your Honor. It is a requirement that for force that for something to be interpreted as force, it has to be based on physical contact. That didn't happen in this case. The state doesn't contend that happened in this case. The state maintains that the only physical contact that the defense made with anybody is the physical contact that the defense made with his flashlight when he pressed a button. All right. But then we go to or. What else would be required? Because that clearly doesn't meet the requirements. There's no physical contact. So then we go to or a threat of strength, power, or violence. And I ask the state, where is the threat of power, strength, or violence from the defendant? And of course, in hindsight, it's always easy to say, oh yeah, something could have happened. But Your Honor, anything could happen. Your Honor, when I stepped into my vehicle this morning to come to court, I took a risk. I took a risk that I might get hit by a car. Anything could happen. Of course, the risk is always that something could happen. But we have to look at what reality is. What really happened? Nothing. Nothing happened. The only thing that happened was somebody got offended. And now ultimately because there's a personal vendetta against me in this county, which has been proven by the prosecution. The prosecution can object if they'd like, but it's been proven by the prosecution. Jared Holtzclaw has written up an opinion about me just on his own, completely on his own, on a completely unrelated matter, saying that what I do on a regular basis amounts to, I believe, aggravating public officials. But of course, shining a flashlight, recording public officials with a video and audio recording device It's been ruled by the 7th District Court of the United States to be a constitutionally protected activity. Now, converting a constitutionally protected activity into a crime just because public officials may find behavior aggravating, it seems that we have lost what it means to be in America. That because you might aggravate a public official, because you might annoy a public official, and Your Honor, I don't contend that I'm not annoying. The defense does not contend that he is not, maybe a bit annoying to most people. Right? It's all a matter of subjective opinion. But because of an annoyance, I don't think that a criminal charge need be brought against somebody. And also, I'd like to put into the record that as a result of this Class A misdemeanor being charged to me, a separate court was inclined, that court being the Honorable Vermilion County Court, Special Judge Hunter Reese, that court was inclined to hold a bond revocation hearing for the defense in a separate matter, a completely unrelated matter. And the bond revocation statute in Indiana says that a Class A misdemeanor you have to find, as a judge, you have to find that clear and convincing evidence has been found by you to say that a Class A misdemeanor was committed by a certain suspect. But anyways, the state here is charging me with 3 offenses in this court. We've got a Class A misdemeanor resisting law enforcement. We've got a Class B misdemeanor false informant. We've got a Class C misdemeanor encroachment. The only charge that the defense contends that 0 probable cause existed, and I say 0 because I mean 0, was this resisting law enforcement. But damages have been sustained by the defense simply because it was charged to me so frivolously. And the other court basically viewed it in the light most favorable to the state, as I contend most courts do. I was forced to sit for 11 days in a county jail, in Vermilion County Jail, as a result of this charge being brought against me, when no forcible element was met. No forcible element could be seen by a reasonable person to have existed in this case. So I guess with that, I'll wrap it up. I just wanted to make it very clear the defense suffered exorbitant damages as a result of this. The defense still suffers damages. Writing up this stuff is not a easy or simple thing to do, as I'm sure the court knows. So with that being said, thank you very much for hearing me, Your Honor. I would like to deliver 4 separate pieces of case law to the court.
The state wishes to respond.
Yes, Your Honor. Yes, I would start with Mr. Hendry's last point as to the reason why he was revoked in, I think it was Vermilion County. The judge actually never ruled on the state's first motion to revoke bond, which was based on the Class A misdemeanor. The Vermilion County Court only ruled on the state's second motion, which only referenced the Class C misdemeanor, which is not the reason that we are here for today. So that is a non-issue as far as the state's concerned. The defendant also, frankly, misstated the law. The case law is clear that there's no requirement of physical contact, and I think that is in the double check just so I don't misspeak here. Well, City of Hobart indicates that, and specifically, I finally found it, Walker versus State, which is 99 Northeast 2nd, which I referenced in my briefs, 2013 Indiana Supreme Court case. He held that the Supreme Court has never held that actual physical contact between the defendant and officer is required to sustain a conviction for resisting law enforcement. The definition of force and forcible that Mr. Hendry was using is the Spangler definition, I believe. The court goes on to say that the line after Spangler, the court goes on to say in Marcy versus State that the definition of forcibly, and I would contend forcible as well, has been slightly softened since Spangler was decided, and the line between what is and is not forcible resistance is blurry to say the least. So the contention by the defense that there's a hardline rule on what force is and what it is not is simply untrue. As far as power or force and the defendant's contention that light does not have mass, so therefore it does not have force, I believe is the logical progression that he made. The state would introduce the mere idea of a laser. There are crimes specifically about pointing lasers in people's eyes in airplanes. And so the fact that there is no source of light that could reach the level of force requisite for this statute is incredible, unbelievable. More specifically related to this situation, Mr. Hendry injected himself into this situation. He was not the subject of the stop. This interaction was not based on his behavior initially. He happened upon it by whatever means it is that he happens upon these things, and inserted himself into the situation, which he may have a constitutional right to do, but he does not have a constitutional right to interfere with the law enforcement activity. On to the use of his body, I think that Mr. Hendry today admitted to this court that he did use his body to point that flashlight, which could be construed by a court, not necessarily this court, or another finder of fact as using force to obstruct. I'm not asking the court to do that today, obviously. This is not a fact-finding hearing. But it is certainly a reasonable conclusion that a finder of fact could reach. In addition to all of that, this court found probable cause for the filing of these charges at the time that they were filed or shortly thereafter. And for those reasons, for that reason and the reasons that I had just mentioned, the state believes that this prosecution should be ongoing at this time and would ask this court to find in favor of the state in regards to this defendant's motion. Thank you.
Your Honor, do I have permission to speak?
Yeah.
So, physical contact required. Mr. Brent Seymour made the claim that I made the claim that physical contact is required. I did not make that claim. I made the claim that physical contact and I made that very clear, or a threat of strength, power, or violence is required. Mr. Seymour completely went over that point of my talk. Completely skipped over that, because if the court actually considers the fact that it's not a use of physical contact that the defense is claiming to require, but a physical contact or a threat of strength, violence, or power, that's what's required. I didn't make the claim that it was physical contact. So Mr. Seymour belaboring the point that there's case law that says that physical contact is required is curious to me. Forcible, while there may be a case that says that the definition has been slightly softened, the definition has been reinforced time and time and time again. Go back to my point. Physical contact required or strength, violence, and power. I believe that's the Walker court. I believe it's also the Pogue court. So I don't know exactly what the state is getting at when he keeps belaboring that point. Then the state goes on to talk about laser beams. I don't know where I'd get a laser beam capable of, I don't know. I've never personally seen one. But either way, I think that we're talking at this point kind of about some Star Wars stuff, some Star Trek kind of stuff. We're not dealing in the realms of reality here, and that's something that I would encourage the court to operate in, is the realms of reality, because the state claiming that I could have used a laser beam to commit force. The state claiming that I could have had a light, powerful enough to commit a use of force. Again, I'll say it. I'm not familiar with these lights personally, but could have is a pretty indicative use of the language. Maybe if I did have something that could, burn through, like a starship destroyer or something, whatever they have in Star Wars. Maybe if I did have a light like this, but again, we're dealing with the realms of sci-fi with science fiction. I don't know exactly what he's talking about. And then when he talks about there's laws for airplanes, well, there may be a law for an airplane. But of course, we aren't dealing with an airplane today. And then when he says that I injected myself, that's just an outright lie, Your Honor. There's an outright lie. At the beginning of the interaction between the defense and the state's witness, Ryan Van Horn, at the beginning of this interaction, Mr. Van Horn injected himself into Mr. Hendry's activities. And I was standing there when Mr. Van Horn said, hey, started barking orders at me. I said, sir, do your job, please. I said, focus on what you're doing. So the idea that I injected myself I think that's just, for lack of a better term, it's ridiculous, Your Honor. And I was not the subject of the investigation, but I would restate the point that the subject of the investigation was gone. The subject of the investigation was absent. There's nothing to interfere with. So I think that, and I wonder why the state didn't bring that up as well. The subject of the investigation, while it wasn't me, he wasn't even present. So I do wonder why the state didn't bring that up. But, Your Honor, I think that at this point I've made all the points that I can. Of course, I am a layman, but I think that's about it for me, Your Honor. Thank you.
All right. What the court's going to do is, since there was the motion and there was a response to it, what I normally do is allow the parties 30 days to file any additional briefing that they would want to based upon the arguments here today. After the 30 days, then the court would consider that under advisement, and then I'll set it for a pretrial with the other case. So I figure if we set the pretrials out about 60 days, that gives you guys an opportunity to file a brief within 30, if you choose to. Nobody's required to, but if you choose to, you file any additional briefing within 30 days, then that would give the court some time to make sure that, I've had time to review everything today and everything has been filed, and then a decision would be made before that pretrial. So if we set, I was looking about 60 days out from today, so that would be, looks like that'd be right around the 1st of September. So we could set both of them for a pretrial conference on September the 4th at 9.